Good morning. I'm Sienna Roginski, Membership Service Director for the South Dakota Retailers Association. Welcome to our webinar on HR issue updates. Today's program will feature a presentation by Chris Hoyme of the employment law firm of Jackson Lewis, a nationwide firm that deals with all facets of employment law, entirely from the management aspect. Chris is a principal in the firm's Omaha, Nebraska office. The firm also has offices in Rapid City, and Chris is a member of the South Dakota Bar. SDRA has a retainer agreement with Jackson Lewis that allows our members to contact the firm at no cost to get answers on general labor law questions. In addition, SDRA members are eligible for discounts on certain Jackson Lewis services, including developing employee handbooks and representation in labor lawsuits and unemployment insurance appeals. Just have a couple of notes before we start the presentation. All the phones of all attendees are muted, so we won't hear any background noises. We'll have a question and answer period for Chris at the conclusion of his presentation. If you'd like to ask a question, go to the webinar panel on the side of your screen. You may need to click on the orange arrow to maximize the panel. Where it says type a message here, type in your question, then we'll then click on send. We'll now turn the presentation over to Chris Hoyme. Thank you.
Thanks, Sienna. Good morning, everybody. This is Chris Hoyme. Most of you, if not all of you, we are very familiar with. We have enjoyed at Jackson Lewis our affiliation with the retailers that is now going on a decade, where, just as Sienna indicated, we provide transactional employment and labor advice for free, a significant discount in the event you get involved in litigation, unemployment appeal, etc., and also the handbook program that many members are taking advantage of. Another service that we provide through the retailers are these legal updates, and today we're providing a relatively short webinar on the Department of Labor overtime changes that are coming right around the pipe effective January 1st. In addition, we're going to touch briefly on a proposed update to our tipped employee rules, as well as discussing some website accessibility case law that is becoming more and more relevant to retailers. So the name of the game, as always, when I present is to make this practical. We do have a period at the end to take questions. So let's proceed and get into our first topic, which is the overtime rule changes. We're going to cover that proposed rule. We're going to evaluate what changes may need to be made in fairly short order, and how can we ensure that we are complying with the new rule. Most all of you are aware under the Fair Labor Standards Act that the Department of Labor sets overtime rules, and that if we have hourly employees, non-exempt, they are to be paid a minimum wage, and if they work more than 40 hours in a work week, they are to be paid overtime, which is generally time and a half. Basic stuff that all of us probably are well aware of, but the new rule will impact what classification our non-exempt employees will now fall in. All of us should know that presently the minimum wage in South Dakota is $9.10 an hour, as opposed to the federal minimum wage, which is $7.25. In order for us to classify an employee as non-exempt, non-exempt means we pay them a salary. Non-exempt means that they don't get overtime. They must meet a number of tests. One is the salary basis test. How much are they going to be paid in their fixed salary that is not subject to reduction because of variations in the quality or quantity of work performed? Then the salary level test, the amount of salary must meet a minimum specified. And finally, and critically, the duties test, that in order to qualify for an exemption from overtime, to define someone as exempt, you must meet significant and detailed criteria set out in the DOL regulations that all of us should be familiar with. Now, today, we're only talking about the minimum salary test. The duties test, in order to classify someone as executive, administrative, computer professional, whatever it is, we are not discussing because the new rule does not impact it. It is critical to understand that in order to classify an employee as non-exempt, pay them a salary, they must meet the duties test, and the duties test is set out in detail on the DOL website. If anybody wants me to forward those criteria, I'd be happy to do so, but it's very easy to find on the DOL website. But today we're talking about salary, and as many of us remember, back in 2016, a number of lawyers, consultants, associations were telling you that the salary increase to qualify for exemption was going to be increased dramatically. And back in 2016, as many of us recall, we were told we had to get ready because effective January 1st of 2017, by many calculations, the minimum standard salary level was going to increase to $47,476, $47,476 under the Obama administration. And we were told that we needed to prepare for that, and in many cases, almost, and in fact, double the minimum salary threshold that we were operating at the time, $23,000 plus. But as all of us recall, in a somewhat surprising ruling by a Texas court, the new rule, proposed rule, was enjoined, and later that fall, of course, we had an election. So all of the proposed changes in the minimum salary test were basically put on hold, and we went back to the old $23,660, and now 3 years later, the DOL has issued a new proposed notice of rulemaking that will become effective on January 1st, and it looks like it would be almost impossible, if not impossible, for these new increases to not take effect. Unlike last time, we are very, very confident that these new rules will become effective in all likelihood on January 1st. What are the new rules? We are increasing the minimum salary threshold from $23,660, which we've been at for a long time, to $35,568, or $684 a week. This again is much, much less than the Obama $47,476 proposed rule, but nonetheless, it is a significant increase. So in order to classify anyone as salaried, in most every case, our minimum salary needs to be increased to $35,568. Likewise, if we have a highly compensated employee, someone we're classifying as an HCE that can be salaried without meeting any of the duties test, that number is increasing to $107,432. But we're going to be focused on the minimum salary, the $35,568. And we need to understand that under the new rule, that 10% of this $35,568, and under my Nebraska and South Dakota math, that number comes to $3,556.80, that we can take up to 10% of that minimum and pay it through incentive compensation, such as commissions, non-discretionary bonuses, not discretionary bonuses, but non-discretionary bonuses and other incentive payments. And we can do that 10% on an annual basis. We can wait till the end of the year, December 30th, for example, to pay that extra 10% to get them to the minimum of $35,568. This is distinguished from the Obama rule that required such payments to be paid at least quarterly. Remember that the 10% rule does not apply to highly compensated employees, that they must be paid at least their full standard salary level without regard to incentive compensation. Also, be aware that there are no automatic increases built into this proposed rule, unlike the previous rule that would be increased every 3 years. So we don't have automatic increases, and as employers, we should take comfort in that. Does that mean this won't be increased? Of course not, it could, but we don't have them built in regardless of the economic circumstances. So, nuts and bolts, when is this rule effective? January 1st, 2020. The new minimum, $35,568 annually, must become effective by January 1st, unless we are explicitly told otherwise by the courts or Congress, which we do not anticipate. So remember, we're not changing the duties test in any way, shape, or form. Those specific and detailed criteria, and you're probably getting sick of me talking about it as a broken record, but those criteria set out on the DOL website on what the duties have to be to classify an employee as exempt and therefore not have to pay him or her overtime are laid out on that website and must be complied with, and nothing we talk about today impacts that. So remember that these salary increases are considerably more modest than what was proposed under the Obama administration, that many of us may have already made changes that we don't have to change it again because we're above the $35,000 threshold, because we made changes back in 2016, that we do not expect any legislative changes. And the incentive for these changes to occur will be that if for some reason someone tried to block them because they wanted to make them higher, let's just speculate that a Democratic-controlled Congress would try to raise that number. Remember, if they failed, and it's likely they would with a Republican-controlled Senate, if they failed, we'd go back to 23,000 plus. So the consequence for not passing this is significant. If it is passed, we get to that 35,000 number, and politically it would be very risky for someone to try to shut this down now in an attempt to raise it. So we know with virtual certainty that the number is going to get raised. What should be our strategy to comply? What alternatives are we faced with in terms of compliance? Okay. Number one, we simply increase the salary level for affected employees and retain exempt status. If we had, for example, an employee classified in an exempt classification, they met the duties test, but they were only making $30,000 a year annually, we would have to increase that number to the 35,000 plus that we've been talking about, 35,568. We simply increase it effective January 1st, and then they can continue as an exempt employee that we don't have to pay hourly to. So obviously that will increase your labor costs under that option. How can we push back against that? We could reduce fringe benefits. We could have smaller wage increases. We could delay promotions. But one thing we will have is, let's say we walk into our exempt employees and we tell those that are making $30,000 they're going to get a $5,000 plus wage raise annually. Practically, is that going to have a domino effect, a potential domino effect on other exempt employees? And the answer is, of course. If someone is making $37,000 and they've been there 10 years, and suddenly someone who's been there 6 months is getting a raise to $35,500 plus, there's going to be some questions asked. And breaking it down fairly simply, that question's going to be, when is my raise? I've been here 10 years. Chris or Betty just got a $5,000 a year plus raise. When is my raise? Does that raise impact me? And that will be a question you have to ask and answer, and in all likelihood are going to have to adjust accordingly, just from an employee relations perspective, because of experience, because of longevity, because of performance, whatever it is. But obviously, just moving up the floor and walking away doesn't work in an employee relations scenario. We have to think about adjusting everyone. So, one, we can simply raise those exempt employees' salary who are below the minimum to the minimum or above. Option two, we can simply sit down with our exempt employees that won't be making enough to qualify as exempt and say, we're going to change you to hourly. We're going to change you to non-exempt. Therefore, you have to record your time. And if you work more than 40 hours in a week, we will pay you and are obligated to pay you overtime. So that is option two. And obviously, if we do this, we could adjust their hourly rate to account for anticipated overtime. So the message would be, hey, look, we're reclassifying you as non-exempt, as hourly, and we're going to make sure you get paid the same, but we're going to pay you an hourly rate that also anticipates, based on our research, the amount of overtime you would be working, so that although you'll be working 48 to 50 hours a week with overtime at this hourly rate that we're calculating, you will be paid the same as if you were salaried. So that is an option, and that is an option that many employers follow. It does have some consequences. You can imagine some people associate working as an exempt salaried employee with some type of status. And if that status is taken away, that could have an employee relations consequence. Likewise, you have record keeping, timekeeping consequences and burden associated with transforming or transferring someone from an exempt to non-exempt status. You also have overtime obligations, obviously, if you work over 40. Another option is simply to reduce hours to avoid overtime and shift work to other workers, meaning this rule is set up to simply not have to pay overtime. And if you have someone who isn't classified and you want to ensure that you're compliant with the law, you would change them to hourly, and you would, if you could, make sure you didn't have any overtime so as to put that variable of increased costs. You could also simply move to avoid overtime, just hire more part-time workers who would never get over that 40 max, because that's what will trigger this whole investigation is, do you have anyone who is improperly classified who is working more than 40 hours? If you don't have any scenarios where somebody would be working more than 40 hours in a work week, then you really don't have risk. Only when someone works more than 40, if they were improperly classified, do we have risk. And it is very hard for employers to say, well, we never have any overtime, therefore we don't have anything to worry about. So this option can be very difficult. Okay, now if we change someone from exempt to hourly, we need to make sure we understand consequences, recording of time, loss of flexibility. We have more variable income, up and down based on overtime. Employee morale, as we've discussed, may be impacted. We may have to hire more workers depending upon the specific immediate need. You're a little bit more mercurial and unpredictable with your labor costs. Now, the silver lining, of course, is that in order to anticipate these consequences, we have to be absolutely accurate that we have audited all of our exempt positions. We've looked at the duties test and we've looked at the salary test to determine whether indeed we qualify. We've done an overtime study, we've done customer studies, so we have a very detailed, certain, well-researched calculation as to what our needs are. But the takeaway from all of this is on an annual basis, we should be reviewing our salaried classified workers, our exempt workers, to make sure they satisfy all the criteria, duties and salary. And this new rule will give us a great opportunity to do that. Now, one difficulty, of course, is, let's say we now have, due to salary being paid, let's say hypothetically we have a 10-year employee who is salaried at $38,000, and we have a 1-year employee who was classified as exempt, but now, because they're only making $30,000 a year, in my example, they're changed to non-exempt. They're changed to hourly. They have the same title and responsibilities, but one is hourly and one is not. One is exempt and one is non-exempt. Is that okay? Well, from a legal perspective, I would argue it is somewhat risky because we may have an issue with the duties test to make sure the duties test are clearly satisfied. And if they are, you probably don't have legal risk, but you may have practical risk in that an employee will ask, well, how come I have the same title, but I have to punch a clock and Bill doesn't, for example. So you may have an employee relations issue there. And obviously, if you don't satisfy the duties test, even though you're paying someone $38,000, but they don't have the necessary supervision, discretion, or whatever is necessary under the duties test, that classification will be improper. So this does have some consequence. If you have the same title and within that title you have exempt and non-exempt employees, that could have primarily a practical consequence that we need to work through. This is an excellent question, and I get it a lot, which is, what's the best way to communicate the decision to employees who are being reclassified as non-exempt? You know, the meeting would occur, the hypothetical, I'll use myself, hey, Chris, you do a real nice job here. Your salary has been $33,000. There's a new law coming into effect that would require us to pay you beyond what our scale allows in order to continue to classify you as salaried. Therefore, we're going to move you to hourly. You're getting paid the same. You'll still have the opportunity to make the same amount of money, and under overtime opportunity, you may even have opportunity to make more. What the new rule will allow us to do is to use the rule very legitimately as the reason why we are changing someone to hourly, if that's the option that we select. This is opposed to the conversation where, let's say we didn't have the new rule, but we had improperly classified someone. We discover that at the end of the year audit that I'm talking about. For example, we discover somebody didn't satisfy the duties test, and we have to sit down with them and say, hey, you know, you've been improperly classified as salaried. We need to move you to hourly. And at that point, people will say, employees will say what? Well, if I've been improperly classified and been working overtime, who's going to pay my overtime that I've incurred in the last 2 years? And we'd have to have answers to that. And we may, and in that circumstance, we may have to pay them for any overtime that was accumulated due to our mistake in classification. We don't have that issue here because we are changing someone from salaried to hourly based on a change in the law. So it's a pretty simple conversation. It's an honest conversation. The law is changing. We have to change you to hourly. You now have to record your time, but hopefully we can tell them, and I'm sure we could, saying you still will be making the same. You'll just be doing it in an hourly fashion. That conversation isn't as tricky from a legal perspective as the conversation I just described, where we simply made a mistake on classification that we discovered during an audit. Okay? Now we'll take some more questions at the end, but I did want to hit on some proposed changes to the tip credit rule. Specifically, we have a change to the tip credit rule where we're in a comment period now until December 9th. After December 9th and the comments are reviewed, then the DOL, after considering the comments, will eventually issue final regulations. But this proposed change would impact those of you who have tip pool or tip credit in the following way. And remember this is the overlay. Right now, this is just a proposed rule change. It is not, the law has not yet changed, and we need to continue to monitor, and the SDRA will keep you well aware of the status of this proposed change moving forward. But change is in the air. It has not occurred yet. And if it does, I would guess it would become formally effective sometime in the spring at the earliest, and we'll let you know. But under the proposed regulation, employers, managers, and supervisors would be prohibited from keeping tips received by employees. Okay? Now, secondly, for employers that do not take a tip credit, it allows employees who don't generally participate in a tip pool, such as cooks or dishwashers, to share in a mandatory tip pool with servers, hostesses, and the like. So for those employers who don't take a tip credit, we can set up a tip pool that would include employees, as long as they're not supervisors or managers, that would include employees that don't get tipped directly in a mandatory tip pool. It would also quantify the civil money penalties if this is violated. If an employer unlawfully kept tips when they're not supposed to, generally you're looking at fines not to exceed $1,100 per occurrence. Also, for those employers that do take a tip credit, the regulation, the proposed regulation, would do away with the 80-20 rule and would simply say that an employee in a tipped occupation who performs related non-tip duties contemporaneously with his or her tip duties for a reasonable time can participate in the tip pool and the tip credit. So the opportunity here to get away from that arbitrary tip, that arbitrary 80-20 rule is significant. We will keep you all up to speed on this. We will let you know where we come out. You do have opportunity, as I know the National Federation of Retailers has done, to offer comments, but all of you have the opportunity to offer comments to the DOL as well. And if you'd like any information on that, either let the SDRA know or let me know directly, and I will show you the procedure that is followed to make comments to the proposed rule. Okay? Now, finally, and this is an interesting issue for all of us, and that is website accessibility as it applies to the Americans with Disabilities Act. In the Ninth Circuit, which is out west, a gentleman named Guillermo Robles tried to order a Domino's pizza on his phone. He was blind and is blind, and his screen reader couldn't read the mobile app on his phone, and he was unable to utilize the app and therefore couldn't order a pizza. He brought a lawsuit, federal court, and Domino's argued that the Americans with Disabilities Act, Title III specifically, did not require a website to be publicly available or accommodated because there were other ways and options to order the pizza. Title III basically says that if I go to Domino's and I, as a member of the general public, want to go inside and order a pizza, or I go to a restaurant and want to go inside and eat, it's open to the public, and therefore that restaurant or Domino's needs to make sure that it has accommodations, reasonable accommodations for people with disabilities, a wheelchair ramp, screen reader, whatever it may be. What this gentleman says is that entities who serve the public, i.e. Domino's, who have a website, need to make sure their website is accessible, reasonably accessible with accommodation under the ADA. Domino's said, no, the ADA shouldn't apply because there's other ways they could order. It's not like if you want to go into the restaurant and you can't get in, you don't have any other options. They argued that, well, there are other options to order. You know, pick up the phone, whatever. The National Federation of Retailers made the same argument in a brief to the Supreme Court as well, because this went up to the Supreme Court. The Supreme Court refused to take the case, and therefore, in this limited jurisdiction of the Ninth Circuit out west, this case and this finding that the ADA may apply in this website accessibility issue is getting the attention of all restaurants, all retailers with websites. But right now, we don't have any uniform application. In other parts of the country that aren't within the Ninth Circuit, we don't have application. So we're waiting for this case to go to trial, because now the issue, and Domino says they're going to fight it, they're going to trial. Now the issue isn't whether the ADA applies, because the court has ruled that it does. The question now is whether that website was accessible within reasonable ranges to the blind in this case. So what all the fundamental associations that represent retailers, including your National Federation, are arguing is that we're going to have, willy-nilly law and regulations that are not uniform across the country. Some retailers, some companies could say, we don't have to change our website because we're not in the Ninth Circuit, or we don't have to do anything about it. Others will say, well, we do. What is reasonable? What is defined as accessible? What exactly do we have to do? So now the argument on a practical level is we need uniform regulations as to accessibility across the country. And I know your federation on both a federal and local level are working towards that. But what you need to do, compliance strategy, the number 4 on the PowerPoint, what we need to do is keep an eye on the Domino's case. We need to work through our local, federal, and state legislatures to get uniform accessibility, because this could turn out to be somewhat of a Pandora's box for anyone who has a website open to the public that sells goods and services. So it's kind of a narrow issue, but it's certainly gotten a lot of attention from a retail perspective with online sales and purchases as to what constitutes accessibility to the disabled under the ADA. So I know many of you may be going, well, that sounds like kind of a narrow legal issue. Well, if you're a business and you have a website, we could have ADA issues. And remember this, under South Dakota state law, the ADA applies to virtually any employer that has 1 or more employees. So it probably could apply to all of us. And we need to just monitor it. We haven't seen anything in South Dakota specifically, or in the 8th Circuit where South Dakota lies as to this specific issue. That's why we were all looking at the Supreme Court to take the case and give us uniform law, but they elected not to do that. So in a nutshell, keep your eyes and ears open, and we will keep you informed as the law and the case law progresses. That's all I have in terms of presentation. If there are any questions, I'd be happy to take them now.
All right. Thank you, Chris. We do have a few questions for you, so I will just start here and you can give us your answers.
Sounds good.
All right. What kind of notice do you have to provide to employees if you reduce fringe benefits or reduce hourly pay rates?
Well, the answer is, as the lawyer goes, it depends. Generally, it's always a practical idea to give, I like to give at least 30 days notice from an employee relations perspective, if possible, so people can adjust their, their finances accordingly. I know depending on the industry and the city and the state, it can vary. But I would deal from a practical perspective where you can, that if you are going to certainly lower somebody's compensation, that we give them reasonable opportunity to anticipate that. I'd like to be more specific, but there's a lot of variables across federal state lines as well as the type of industry you're in. So,
would that same 30-day notice apply if you were going to change them from salaried to hourly or from hourly to salaried?
No, it would not, because the trigger for notice generally is if you're going to lower somebody's pay. And again, many times it's just from a practical perspective, but simply changing their classification, as long as they're going to get paid the same or more, you should be fine.
Okay. Is there any regulations on whether that's a verbal notification or a written?
There aren't any regulations, but certainly within a personnel file, you would want to note that. And of course, your payroll will be the primary paper trail, if you will, or digital trail, if you will, of change in pay structure, certainly from.
Another question, is there any advantage to requiring salaried employees to record actual hours worked?
Yeah, the answer to that is generally if we require our salaried employees to track their time, record their time on a regular basis, we risk jeopardize their classification, because if you're exempt and salaried, you don't have to track your time, and if you are required to, the DOL would say perhaps you're not truly exempt, and maybe you've been misclassified. Now, having said that, certainly if you are doing a wage study or an hour study where you're trying to determine how long a particular task takes, how long a particular shift works on a task, etc., if it's part of a legitimate study where we're tracking time to determine how we can better serve our customers, how long it takes to make a product, whatever it is, then we're fine. But if we would just have a blanket rule requiring all salaried employees to track their time, I would argue that you increase the risk that some of those salaried employees would jeopardize, and the DOL would probably have an adverse reaction to that.
Okay, and just one other question, just to clarify, can an owner participate in a tip pool?
No. And it'll be even clearer. It'll even be clearer under the new reg when and if it becomes, because it explicitly says no. But even now, and the new reg, if and when it becomes law, and I think it will, it uses the term owner, supervisor, or manager. So I would not have an owner participating in a tip pool.
Okay, well, those are all the questions we have for today. Again, as a reminder, SCRA members may contact Jackson Lewis Law Firm with basic employment law questions at no cost. For information on how to utilize that service, contact our office at 605-224-5050. And we want to thank everybody for participating in today's webinar.
Thank you, everybody. Appreciate it.